Here's a problem you face. You're dealing with an abusive company, a company that's lying to you, and so you sue them. And you're in state court or federal court, wherever you are, and the company says, wait, stop, freeze this lawsuit. There's an arbitration agreement. You cannot go against us in court. You have to arbitrate your claim. So you say, fine, I'll arbitrate my claim. Well, see, that's not what they're expecting. They're expecting you just to go away. And so you say, fine, we'll arbitrate, and you move forward with it, and they go, well, wait a minute, we're going to have to start spending a lot of money here. We weren't expecting that. So they go, you know what? We refuse to pay. We won't pay our portion of the bill. What do you do? Because you were in court, and the judge has now frozen this. So you go to arbitration, and the company says, we're not going to pay. What do you do? Well, you go back to court, and you say, hey, they gave up their right to arbitrate. That's what we'll look at in this case from the 11th Circuit. It says do not publish, which just means it's not binding, but I'll just say this. It still has a lot of power. It's from 2019. It's still good except for one thing. Almost every court got this wrong about arbitration, and the U.S. Supreme Court fixed this, and we'll cover this in a future video where a unanimous, which is kind of surprising, unanimous U.S. Supreme Court said, hey, all you guys have got it wrong. Let us straighten you out on exactly what the law is. But it wouldn't change the result in this case. So here we have a couple of people here. We've got the company, and this is Smart Pay. They sell or lease basically smartphones, mobile phones. And then we have the consumer, Freeman. And so I'll typically just call them, the company and the consumer. And so what happens is, the agreement says we'll do binding arbitration instead of a lawsuit. And the agreement says there's two possibilities for arbitration. You can go to AAA, American Arbitration Association, or you can go to JAMS, J-A-M-S. And you get to choose. Whoever wants to arbitrate gets to choose. But if the company chooses, then the consumer has the right under this agreement to within 30 days flip it to the other organization. So here's what the agreement says about arbitration. SmartPay, assuming the consumer brings it. SmartPay will pay the initial filing fee, and then basically everything else is split. Okay. Now, that is totally contrary to the consumer rules. The consumer rules, and we'll see exactly what I mean by that, these say that the consumer pays a small amount, and then they never pay again in arbitration. So we've had arbitrations. I'm thinking of one 20 years ago, where we used JAMS, and they sent a bill to the credit card company for like $30,000 and say, go ahead and pay this. This will get us going. Of course, the credit card company completely freaks out. Even just within the last couple of years, we've had these with JAMS where they say, okay, that'll be $10,000 or $15,000. Pay us up front. Now, so you don't have to pay a judge, but you do have to pay the arbitration association and the arbitrator. Arbitrator may be charging $600,000, $800,000 an hour. It adds up, and the company has to pay that. So what happens is there's a lawsuit under the TCPA. So this is for robocalls to a cell phone, then the FDCPA, Fair Debt Collection Practices Act. And the company says, well, wait a minute, we have to arbitrate. And let's look back at this. There's a claim 250 of these calls. Well, those can be $500 a call. It's $125,000, or it can be 3 times that much. So you can see why the company being sued is like, wait a minute, I don't want to be in court. This is too dangerous. We'll just sort of slap down this arbitration card and you'll just go away, because that's how things have worked for most lawyers. Now, again, we've been doing arbitrations for 20 years and actually even longer than that. But that's not how most lawyers who represent consumers have done things. So the consumer here chooses JAMS, which is what we almost always choose, JAMS. We think it's a better forum for us, and it's very expensive for the other side. And so the other side doesn't like it, but they chose it as an option. And so the consumer pays $250. There's an initial filing fee of $1,200 at the time of this. I don't remember what it is right now. And the consumer went ahead and paid $250. Now, the consumer says this is a consumer arbitration, consumer agreement. And JAMS says there's 3 requirements. Number 1, you have to be a consumer. Kind of makes sense. Number 2, the company has to have either drafted the contract or had it drafted on their behalf. And so that could be like let's say portfolio recovery is collecting a Synchrony bank debt. We sue portfolio recovery and they go, wait a minute, you have to arbitrate. Well, even though portfolio recovery didn't draft the agreement, it was drafted on their behalf. So number one, consumer. Number two, the company drafted it. Number three, the consumer is required to accept it. Now, here's what JAM says. All other costs must be borne by the company. So the consumer can only be required to pay up to $250. So SmartPay says, well, wait a minute, this is not consumer. And because the consumer had the right to opt out. JAM's rejected that. Now, why would they want this to not be consumer? Because if it's commercial, then basically both sides pay. Well, again, each side might get a bill for $10,000 or $20,000 from JAMS. So SmartPay is trying to use that big bill to basically silence the consumer here. It didn't work. And then SmartPay, the company, says, well, wait a minute, we're deeply offended. We wanted to pay the whole filing fee. And this consumer paid $250. Well, what can we possibly do? We can't arbitrate with JAMS. You're like, if it really bothered you, couldn't you have paid the $250 back to the consumer? Now, of course, truth of the matter is it did not bother the company. They were just looking for any excuse to get out of JAMS. So the company never pays the $950. That's the $1,200 minus $250 be $950. And so JAM says, basically take it up with the arbitrator. And you have to move forward. You have to pay this or we can't administer the claim. And SmartPay, the company, says we're not going to waive our right to pay the whole amount, which again is so silly. They're just using this as a pretext to try to blow up the contract here. And so they say, well, look, JAMS, we know you're not going to arbitrate it, and the consumer can just go to AAA because they had two choices. We've taken one away. They have to go to AAA. And JAMS says, well, AAA has their own consumer rules that are pretty similar, and they are very similar. And so then the consumer says to JAMS, hey, I want you to put in writing why you're not able to move forward with this because I'm going to take that to the court. And the consumer says, I'm not going to file in AAA. That would be rewarding SmartPay, the company, for refusing to follow the rules here. So the consumer goes back to the district court who had stopped or stayed the lawsuit and said they won't participate. Unlift that stay, unpause it, unhalt it. And the court goes, yeah, you're right. I'm doing that. So granted the motion to vacate the order referring the case to arbitration, lifted the stay because SmartPay had not paid JAM's filing fee. And so then the court has to decide whether or not they have authority to listen to this appeal, and they say they do. And so FAA, which is the law on arbitration, says you have to stay the lawsuit and let the arbitration happen unless the one that wanted the lawsuit stayed or halted is in default in the proceedings. Well, how can you be in default? Well, you waive your right to arbitrate or you refuse to pay the money. That would qualify for it. So here's a two-part test. The second part is no longer correct. The first part is you say, well, has the company waived their right to arbitrate this? Have they given up their right? Have they acted inconsistently? And then part two, has that harmed or prejudiced the consumer? We don't look at that anymore. We only look at what the business did. Did they act inconsistent? Did they waive it? And the court says, you know what? We find that they waived it by refusing to pay the filing fee. And they point out three things here: that the company required arbitration. They said in the arbitration agreement you can use JAMS. And so they're obligated to pay. And they didn't do it. They breached it. And so therefore that's a waiver. And then they talk about this prejudice, which again, remember, is not the law anymore. But they just point out, well, hey, the consumer had the choice of JAMS or AAA. They chose JAMS, and you're taking that away, forcing them to do AAA. That harms the consumer. And so then they talk some more about whether this was a waiver, because the company comes in and says, well, wait a minute, we had the arbitration agreement and JAMS rules, and these things are in conflict. Well, the simple answer that I think the court could have said if they wanted to is, look, when you put jams down as a place that can be the arbitration forum, you agree to all their rules. Okay? Just like if we said, if you and I get into a dispute, we're going to litigate that in the federal court of the Northern District of Alabama. Well, we don't get to then list the rules. Well, you're going to have only 4 jurors and we're going to have 2 judges, and you don't get to do that. You go do federal court and you follow the federal rules. You go to state court, you follow the state rules. You go to arbitration with AAA, you follow AAA. You go to arbitration with jams, you follow the jams rules. But the court says, well, let's sort of show you how these rules can be reconciled. There's a general principle. You have 2 statutes or 2 rules or 2 contractual provisions that seem like they're in conflict. The court tries to harmonize those and make those fit together. And so they say, look, the whole issue here is on the filing fee. And again, so silly, this company going, we're so upset we didn't get to pay the whole amount. Like, well, you refused to pay anything. And they say, you could have paid the $950, and then you could have taken that up, the $250 with the arbitrator. Or you could have written them a check. They didn't say that, but that's sort of an obvious thing. Write the consumer a check for the $250, go pay the full $1,200 to the arbitration agreement by, the consumer paid $250, you pay $950, you give the consumer $250 back. See, it all complies here. And they say you didn't do that, and so now you've lost your right to arbitrate. And what's so important about this case is it shows that these companies cannot play these games. So we're seeing this a lot. Let me just show you the end here. So here's kind of the context. Company says, I don't want to be sued in court. You have to go to arbitration. So you go to arbitration. And then the company goes, I wasn't really expecting you to do that. I mean, we're going to spend a lot of money. Or let's take what's called mass arbitration. So there'll be what's called a class action waiver. You can't do a class action. Every person has to bring their own case. And so then you say, fine. So we're bringing 1,000 cases against T-Mobile, Verizon, Synchrony Bank, whatever it is. And they go, well, wait a minute. Each case might cost us $3,000 or $5,000 or $10,000. You don't expect us to pay all that times 1,000 cases, do you? Yeah, actually we do. And they go, well, that's not fair. We weren't expecting that. Okay. Sort of like having a boss say to you, hey, if you bring in this account or you bring in this business, I'll give you X percent. You bring in this big business, and they go, well, when I told you that, I wasn't expecting to have to actually follow through on. You can't expect me to follow through. Yeah, I do expect you to follow through. So these companies are trying to come up with ways where they say, you know what? We refuse to participate. Now you're stuck. Well, this case that we're looking at and other cases give us that leverage to say, that's fine, but we're going back to federal court, and the federal judge is going to know that you're a complete jerk. You're violating your agreement. Maybe we'll add that to the lawsuit, and then we'll move forward. And then when you get popped with a big jury verdict, you can't go, but we're supposed to be in arbitration. No, you gave up your right to that. So hope you found this helpful. If you like this, we'll have other cases like this dealing with arbitration, dealing with the FDCPA, Fair Debt Collection Practices Act, the FCRA, Fair Credit Reporting Act, other consumer issues. So you guys have a great day, and I will see you later. Bye-bye.